Hello, everyone, and welcome to this latest Pepper Hamilton podcast. Today, I am joined by two attorneys from Pepper's food and beverage practice, and they are Yvonne McKenzie and Stefan Ellis. Folks, welcome. Stefan and Yvonne focus their practice on regulatory counseling and litigation regarding FDA-related products, and that's why they're joining us today. If you go down the aisle of your neighborhood grocery store, you'll find the terms all natural or healthy emblazoned on a growing number of products that often garner higher prices than their competitors. Over the past couple of years, there have been quite a lot of press over litigation facing manufacturers making these claims, from food to beverages and even cosmetics. One of those companies is Kind, which makes those tasty bars and granola. Stefan, can you tell us what the Kind litigation is about and the genesis of this litigation?
Thanks, Brian. Kind is facing a slew of class action lawsuits right now brought by purchasers of Kind products under various state consumer protection laws. Now, the plaintiffs are saying that statements in Kind's labeling that it's natural and healthy are false and misleading. They say, among other things, that the products are not healthy because they don't meet the definition set forth in the Federal Food, Drug, and Cosmetic Act, also known as the FDCA. A lot of these actions have been consolidated into an MDL that's currently proceeding in the Eastern District of New York. We'll be focusing today on issues relating to the use of the term healthy, but that's the litigation in a nutshell.
Do we know what triggered the litigation?
So, Brian, there was a prior warning letter from the FDA issued to Kind, and, it's not unusual for a warning letter or some kind of regulatory or governmental action to spur litigation like this. We see it across the board in our representation of food, beverage, and drug clients, particularly if this action is in the press. It'll grab the attention of plaintiffs' attorneys, and a lawsuit will be filed within days. We've seen that happen. And there are implications beyond litigation, including reputational harm, as many of these companies have a platform that promote kind of a healthy product and a product that's part of a healthy lifestyle. So, predictably, the warning letter here is front and center in the Kind litigation as well and cited throughout the complaint. Now, the Kind warning letter covers several nutrient content claims, which FDA claims are not in line with their regulations. So one of those claims is the use of the term healthy, which is at issue in the litigation. According to FDA, the amount of saturated fats exceed that allowed to make a healthy claim. But there are also several other claims that the FDA had issue with, set forth in a somewhat lengthy warning letter, including claims of antioxidant-rich and a good source of fiber.
You mentioned definitions of healthy in the FDCA. What is that definition?
So if a manufacturer wants to use the word healthy in their labeling, the food has to be both low in fat and saturated fat. It has to contain less than a specific amount of sodium per serving, and it has to contain less than a certain amount of total cholesterol. The specific numbers will vary a little bit depending on what kind of food you're marketing, and those are set forth in the regulations. In addition to those requirements, most processed food products have to have at least 10% of the FDA's recommended daily allowance of vitamin A, vitamin C, calcium, iron, protein, or fiber.
Now, Yvonne, if food companies meet the definition of healthy, does that help them fend off these types of claims?
Well, not necessarily. Simply having the right amounts of these nutrients may not be enough to avoid problems with FDA. So a healthy labeling claim may be invalidated if the label for that product doesn't otherwise describe or characterize the nutrient contents accurately, even if those contents would still qualify and actually meet the definition of healthy.
Can you give us an example where that might happen?
Sure. Regulations that govern the use of healthy require that a food product comply both with the definition and the declaration requirements for any specific nutrient claim that appears in the label. So, for example, a manufacturer may characterize a product as low in fat or low in cholesterol. We've all seen those labels. And that product might very well meet the definition of what low in fat or what low in cholesterol means. But that's not always enough. The regulations may also require that the manufacturer disclose if that's an inherent quality of the product, for example. So apples are naturally fat-free. So a manufacturer of an applesauce could say that their product is fat-free, but they would also have to disclose that being fat-free is not unique to that company's brand or product.
Now, why else might a product with the right nutrients face these types of actions?
So as Stefan already mentioned, the regulations require that products claiming to be healthy have to have at least 10% of the recommended daily allowance of one of several enumerated nutrients. But the regulation also states that a manufacturer can't meet this 10% threshold by simply adding nutrients to a product unless it's done in compliance with the FDA's fortification policy.
Stefan, can you tell us more about the fortification policy?
Yes. So the fortification policy addresses how manufacturers can add nutrients to food products. For example, a manufacturer can enrich a product to replace any nutrients that were lost in manufacturing, and a manufacturer can also add new or novel nutrients to a product for certain suitable purposes, and the policy describes those purposes. The policy is usually non-binding, but it's been incorporated by reference as a mandatory part of other labeling regulations, including the regulation for using the word healthy in food labeling. You can find the policy in the regulations. It's at 21 CFR section 104.20. Now, the policy expressly discourages the fortification of certain kinds of foods, including snack foods like candies and carbonated beverages. More generally, though, the FDA has also expressed a concern that the indiscriminate fortification of foods with little inherent nutritional value might somehow result in deceptive or misleading labeling.
Now, has any court ever addressed the fortification policy you describe?
Yes, it has. In 2009, there was a class action against Coca-Cola, who manufacture the nutrient-enhanced water beverage, vitamin water. In 2010, in Ackerman versus Coca-Cola, a trial court in the Eastern District of New York denied a motion to dismiss because the court found that the plaintiffs had adequately pleaded state law claims for false advertising and unfair competition against Coca-Cola. The labeling and marketing for vitamin water at the time included statements suggesting that the drink could keep you healthy as a horse, or that it could help bring about a healthy state of physical and mental being. Now, every variety of vitamin water contains at least 10% of one or more of the nutrients that are set forth in the FDA regulation, but those nutrients were only there because Coca-Cola had fortified the product. Looking at the fortification policy, the court found that the plaintiffs had adequately alleged that a reasonable consumer would be misled into believing that vitamin water was actually healthy. The question came before the court on a motion to dismiss, but the court gave substantial weight to the FDA's consistent understanding that the indiscriminate fortification of a food product could mislead consumers. The opinion strongly suggests that the court was not convinced that vitamin water had enough inherent nutritional value to be called healthy. And the case ultimately settled earlier this month, and the settlement included an agreement that Coca-Cola would stop using similar healthy claims in its product labeling.
Yvonne, will the fortification policy affect Kind in its litigation?
Well, Brian, it doesn't seem so. It doesn't look as though the Kind's healthy claims are inconsistent with that policy. There's nothing in the FDA warning letter that suggests that the company inappropriately added nutrients to meet that 10% threshold required under the regulations. So it doesn't appear to be a big issue so far. But one of the Kind's products characterizes itself as, quote, plus antioxidants, while another one characterizes itself as, quote, plus protein. So the term plus actually has a regulatory meaning, and it means that the product has at least 10% more of a given nutrient per serving than a comparative product. So in the warning letter, the FDA said they don't know from the labeling whether Kind meets this threshold, so that's the issue that they flagged. But the fortification policy might come into play here because if the plus claim is based on nutrients that are added to the food, it has to meet the fortification policy. So at this point, we don't know enough about the basis of those claims to see if this will be an issue, but it's something to watch.
Now, turning to the natural claims facing Kind, is there any regulatory definition of, quote-unquote, natural?
Well, Brian, the FDA hasn't defined what natural is yet, but it's going to, and hopefully soon. In November of last year, FDA opened comments on the use of the term natural in labeling for food products. And it's one of the reasons it was doing that is because it cited requests from federal courts as one of the reasons for its decision to address that issue. Federal courts facing these types of claims brought by consumers alleging that the food isn't really natural. So the FDA has extended the comment period to May 10th, 2016, And in the meantime, Kind and many other food manufacturers have asked federal courts to stay proceedings in those litigations in anticipation of further regulatory guidance from the FDA. So stay tuned. Notably, though, that some states, Vermont being one of them, have enacted regulations governing GMO labeling, another very hot topic facing food manufacturers. And some of those GMO labeling laws touch on natural claims. So Vermont, pursuant to Act 120, requires food manufacturers to label all products regulated by FDA if they're produced in whole or in part through genetic engineering. That law is set to go into effect in July of 2016. But interestingly, that law also prohibits such foods as being labeled as natural if they do contain GMOs. And there are several other states that have enacted similar statutes.
Stefan, how have these kinds of cases involving false advertising claims of quote-unquote natural come out?
So a number of cases have been stayed while the FDA is seeking comment on this issue. And as Yvonne mentioned, companies like Kind, who are currently in litigation, have moved for similar stays. Some companies, though, have decided that it was better to avoid costly litigation and have entered into large settlements with plaintiff classes on these issues.
And lastly, what are the takeaways from the Kind litigation and other cases alleging false advertising based on natural and healthy claims?
So, Brian, there are a couple of takeaways here. First, having advisors well-versed in FDA regulations review promotional claims is really important, and it can hopefully stave off regulatory action and litigation. Now, this is something Stefan and I do routinely for our clients who manufacture FDA-regulated products. There are several hot-button claims right now, the ones that frequently trigger either FDA scrutiny or litigation, likely both. Natural is certainly at the top of the list, and at this point, a manufacturer claiming its product is natural, potentially taking a big risk. But there are others. In the alcohol space, claims of the product being handcrafted or handmade. A lot of litigation right now concerning those claims. So having an advisor on your team that understands what the regulations say, what the regulators are focused on, and what is going on in the courts on labeling issues is really essential.
Another thing that companies need to be aware of is that this litigation was triggered by FDA action, specifically a warning letter. Now, Kind is doing the right thing here by working with the FDA to resolve the issues, but it's really important that manufacturers recognize that these regulatory actions are often the first step to a much larger litigation proceeding. Regulatory action often spurs litigation. It's really important to be ready for and to have a plan for potential litigation once you hear from the FDA on these kinds of issues.
Well, thank you both. All this talk is making me hungry, and we're going to have to cut our podcast short now. For our listeners, for more information in the food and beverage industry, I encourage you to visit Pepper's website at www.pepperlaw.com, and in the food and beverage industry section, we do have a number of articles and podcasts there for you to read and listen to.